Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. I had a potential client to contact me. She believed she had a discrimination case. And one of the things I always do is ask the client to describe in full with specificity how they feel they were discriminated against. As she described the situation, I was listening to hear keywords that would suggest that she may have experienced discrimination. Well, unfortunately, I did not hear those keywords. And that's what I want to talk to you about today. When you file a discrimination lawsuit, you have to be specific, and the actions of the company and its employees have to be related. The words they speak, the actions they take have to be related to the discrimination that you believe you experience. That is critical. It can make or kill a case. Okay, so let's get started. Title VII of the 1964 Civil Rights Act prohibits discrimination. And we are going to go over the 7 areas that the Act covers. They are race, color, religion, sex, national origin, age, and disability. Now, this discriminatory activity, again, must be based on one of these. It must be based on the person's race. It must be based on a person's color, religion, sex, national origin, age, disability. It depends on what the person's accusation is. Okay? So let's assume for this conversation that the act of discrimination, or at least the alleged act of discrimination, is sexual harassment. There are 3 W's that you must answer in order to convince the fact finder that you were sexually harassed. And they are who, what, and why. Who? You must identify the person or persons. No John Doe in a case like this. It would be a little hard to see an individual alleging sexual harassment and not being able to identify the person. I'm not saying it's impossible, but there should be a person that you identify in this case. Again, unless they're clearly anonymous. What? Very, very critical. What did they say that you construed as sexual harassment? What actions did they take that you construed as sexual harassment? Very important. Again, I can't stress this enough. The statements and the actions must be related to the sexual harassment allegation. A statement like, "Baby, you got to sleep with me if you want that promotion," that infers a strong case of sexual harassment. "Come on, honey, let's get back to work." Well, that's kind of weak. But again, coupled with other statements and actions, it could make that claim strong. The why. Now here you're going to talk about the how, because the how helps answer the why. For example, how did they say what they said that made you feel like you were being sexually harassed? How did they do whatever actions they took? How often did they say it? How often did they do it? How did they respond to your rejection? How did the company respond? All of these factors are going to be important to the fact finder. Another thing, usually associated with sexual harassment, is hostile environment and retaliation. Again, the words and actions must be based on the sexual harassment. Critical. And if you have any questions or require additional information regarding employment discrimination, I provided you a link. All right? Until we see you again, take care. This is Advocate Lucinda, your empowerment lawyer.